Welcome to the debate. Today we are tackling really a foundational question about one of the most critical safeguards in the Bill of Rights, the Due Process of Law Clause of the Fifth Amendment. This clause, which ensures no person shall be deprived of life, liberty, or property without due process of law, well, it anchors a vast array of legal protections we rely on today.
Indeed it does. But the entire modern application of that provision, it really rests on a massive interpretive claim. What did those simple words, due process of law, actually mean back when they were ratified in 1791? Let's call it the conventional view, holds that this clause establishes a broad, robust guarantee of fair legal procedures. The general rules governing trials and government action. I come at it from a different angle. I argue that the original meaning was far, far narrower, strictly limited to the technical sense of specific judicial writs and formal notice. This is a concept sometimes known as the process theory.
And I'll be arguing, though while the language may have originated in a, shall we say, technical context, the clause really must be understood in the broader sense that clearly emerged in the 19th century. It has to apply to fair procedures and general legal protections. Its ultimate end, I think, enduring purpose, was and still remains to prevent arbitrary governmental deprivation of rights, regardless of the specific mechanism the state might try to use. Okay, so the core of my position, it relies squarely on the linguistic evidence available right at the time of the founding. The original meaning of due process of law in 1791 was explicitly technical. It referred to formal legal documents, things like a writ or a precept issued by a court, essentially the technical court order that commands an action or starts a suit. We're talking about literal pieces of paper approximating what we'd now call, in modern legal terms, service of process. Now, this process theory, it requires that any deprivation of life, liberty, or property had to be preceded by this kind of technical legal process. It was about ensuring the executive branch couldn't just act on its own whim without first securing approval from the judiciary. And the clearest evidence for this narrow view, I think, is the contemporary linguistic landscape itself.
Founding-era Americans had a separate and, frankly, much more common phrase for general legal procedure. The rules governing trials, appeals, the overall fairness of a legal proceeding. They used the phrase due course of law. Corpus linguistic analysis is really striking here. Due course of law appeared, I believe, 173 times in founding-era American English writings in the decades just before ratification. Compare that to only 22 uses of due process of law.
That's not a rounding error. This strongly suggests the founders had a phrase dedicated to generalized fairness, and they deliberately chose a different, far more restrictive phrase for the Fifth Amendment. I see why you'd emphasize that, and I do respect the rigor of that linguistic analysis. But framing it that way, that strictly technical reading, I think it fundamentally misses the broader purpose, and it misses the necessary legal evolution for a functioning constitutional government. I mean, if the clause was merely about technical paperwork, it kind of fails its entire constitutional function, doesn't it? The modern understanding, which interprets the clause as requiring legal procedures that are fair, what we can call the fair procedures theory, well, that's deeply entrenched now, and it's vital to constrain arbitrary power, whatever form it takes. This broader meaning, demanding fair play and substantial justice, which is a standard we see cemented in foundational cases about jurisdiction like International Shoe Co. versus Washington, that's consistent with the clause's real purpose, to secure the individual from the arbitrary exercise of the powers of government.
And look, this interpretation didn't just, appear out of nowhere. By the mid-19th century, the U.S. Supreme Court explicitly recognized this broader scope. In Murray's Lessee v. Hoboken Land and Import Co. back in 1855, the court directly equated due process of law with the broader concept of the law of the land inherited from Magna Carta. That was the critical shift, really. It established a robust textual basis for judicial oversight that goes far beyond just checking for, technical court orders.
Okay, let's focus first on that linguistic disparity you mentioned, because I find it, frankly, impossible to reconcile the text with the history you're presenting. If due process of law meant broad general procedure, why on earth did the founders use the less common, highly technical term?
our analysis really reasserts the strictly technical meaning of process. The term process itself was used narrowly, meaning writs, at something like 5 times the rate it was used broadly, meaning general legal proceedings. This deliberate choice, I argue, restricts the clause to controlling how the judicial branch initiates action. So modern doctrines that derive from procedural due process, things like the specifics of a trial by jury, or the rules around pleadings or discovery, these are all matters of general procedure. And that is exactly what was known in 1791 as due course of law, which puts it outside the original narrow scope of the Due Process Clause, or DPC.
That's an interesting point, though. I would frame it differently, thinking about the dynamism of legal language and the very nature of this kind of provision. We are dealing with an anti-arbitrary power provision, fundamentally. So even if the linguistic roots of process were narrow in 1791, should the meaning of the clause remain static, frozen in time? Look at Alexander Hamilton, for instance. He certainly understood technical legal language. When he discussed the meaning of DPC, he stated that the words have a precise and technical import, yes, but are only applicable to the process and proceedings of the courts. His inclusion of proceedings, I think, strongly suggests the term encompassed both the initial process, the writ, and the subsequent formal actions within the court's jurisdiction. The intent seems clearly to ensure that any deprivation happened pursuant to the entire formal court mechanism, not just the initial summons paper.
I'm just not convinced by that particular line of reasoning. Hamilton's usage there is, at best, ambiguous in your favor. Hamilton argued that rights may only be deprived by the process and proceedings of a court. Now, that interpretation supports my jurisdictional sense. The court is the necessary agent for depriving rights, which serves a separation of powers objective. It doesn't automatically mean the clause governs the internal mechanics or the, let's say, fairness calculus within those court proceedings. But we don't have to rely only on Hamilton. We have documents like the New York Rights Act of 1787. It expressly contemplated the two phrases as distinct things. That act stated no person shall be put to answer without due process of law, according to the law of the land. Now, if due process of law was just synonymous with the broader law of the land, that phrasing is, well, it's redundant. It's nonsensical. The drafters clearly knew the difference between a technical writ, the process of law, and the general body of law, the law of the land.
Right, and that leads perfectly into the issue of the law of the land conflation you highlighted earlier. I actually defend that historical development. State courts did begin grafting richer, more substantive meanings onto those state-level law of the land provisions. And when Justice Joseph Story later explicitly read this equivalence into the Federal Due Process Clause in his 1833 commentaries, well, that shift created the necessary constitutional structure for robust judicial oversight of legislation that might burden individual rights. This allowed the clause to secure the individual from, quoting here, the arbitrary exercise of the powers of government unrestrained by the established principles of private rights. History isn't always neat, and the adoption of this equivalence was arguably a necessary correction or maybe evolution to apply the full anti-arbitrary weight of the Magna Carta tradition to the federal government, especially considering the federal government's, burgeoning power over time.
But the foundational shift you cite, the one sort of cemented in Murray's Lessee, it was based on a fundamental misreading of Sir Edward Coke's Institutes. Story argued for the equivalence, yes, but Coke himself defined law of the land very broadly, very capaciously, to include common law, statute law, or custom of England. When Coke used that famous line linking the concepts, he merely stated that the law of the land required due process of law. And Coke, right there, narrowly defined DPC as indictment or presentment, or by writ original of the common law. So what you're defending is essentially judges in the 19th century misunderstanding a canonical legal text decades after ratification. It's a doctrinal error, frankly, that drastically expanded judicial power far beyond the scope contemplated in 1791. If the original text didn't mandate broad procedural fairness, then the courts essentially amended the Constitution themselves when they adopted Coke's error.
Okay, but let's push this. If the clause is only about technical writs, does it just fail completely the moment the government uses something other than a court writ?
like an internal administrative process?
This brings us to, I think, the most significant real-world consequence of this debate. Modern administrative law, precisely. That's exactly the implication. If the process theory is correct, if due process only means writs and formal court processes, then the entire modern federal procedural due process doctrine, which is best exemplified by the Matthews v. Eldridge balancing test, is, well, it's fundamentally wrongly reasoned. That test, the one used to assess the need for a hearing before terminating, say, Social Security disability benefits, it balances private interests against government efficiency. These administrative hearings, they are simply not technical process within the original 1791 meaning of the clause. They are quasi-judicial procedures that fall much more neatly under what was historically known as the broader due course of law. The judiciary has, in this whole context, stepped far outside the original scope of merely ensuring a writ was lawfully issued. Instead, it's actively engineering what it thinks are optimal fairness procedures for the executive branch, and that looks a lot more like a legislative or regulatory function, not a judicial one.
But the due process clause isn't static. It can't operate in an 18th century vacuum. It has to adapt to the sheer complexity of regulation in the modern welfare state. The underlying objective of the clause surely is preventing arbitrary deprivation. In 1791, perhaps the only practical way the federal government could deprive you of property was through a court-issued writ. Today, it's often through an administrative agency decision. So, while the specific test, like the Matthews Balancing Act, might be a modern construction, as you say, the necessity of judicial review to prevent arbitrary action, that remains true to the underlying objective. Whether the government terminates benefits via court order or an administrative decision, judicial review seems essential to ensure that deprivation isn't arbitrary, and that, yes, minimum standards of fairness are met. To argue otherwise feels like saying the DPC just became obsolete the moment the administrative state was born.
I absolutely recognize the appeal of that adaptive argument. I do. But it masks a serious structural problem. If the goal is laudable, and preventing arbitrary termination of benefits is laudable, it should ideally be achieved through legislative means, through statutes, or perhaps even through other constitutional provisions that govern unenumerated rights, like maybe the Ninth Amendment. But achieving that fairness through the Due Process Clause requires stretching the word process far beyond its original technical meaning. It converts what was a jurisdictional check, you must use a court, into a substantive procedural rulemaker, where courts decide what a fair hearing looks like in every context. That is constitutional amendment by interpretation, and it seems based on a post-ratification error in equating DPC with the law of the land. It feels like a fundamental overreach of judicial power, however well-intentioned.
So I maintain that the clause, through its historical evolution and what I see as necessary construction, serves as a vital bulwark against arbitrary government action. Modern governance simply requires judicial review to ensure that procedures, even in these new contexts like complex administrative regulations, meet standards of fairness and substantial justice. And this holds true even if the strict 1791 definition of the word process was narrower. The framers' broad intent to limit arbitrary power, I believe, justifies the more expansive application we see today.
And I would conclude that the original public meaning of the Fifth Amendment due process of law clause was in fact narrow and technical. It mandated lawful writs and formal notice from a court, period. Therefore, the entirety of the modern corpus of procedural due process doctrine, particularly as applied in administrative settings, appears inconsistent with that original meaning. It seems to rest instead on, well, linguistic drift and perhaps a degree of judicial error.
This debate really highlights a crucial tension, doesn't it? The legal principles governing governmental power today rely heavily on a constitutional phrase whose meaning seems to have undergone pretty significant linguistic and doctrinal change since its ratification.
Agreed. And much still remains to be explored, I think, regarding the relationship between the original, perhaps technical meaning of these words and the established, undeniably powerful constitutional practice that has grown up around them over centuries.